Effective dates. There's all tons of effective dates in this new law. They're basically coming up in next year will be a lot of procedures. And the big one, the one that you have to be afraid of, very afraid of for your portfolio of patents, is the inter partes review. This is really inter partes reexamination on steroids, because it'll be a one-year procedure starting at the board. You lose there, you're toast. It's retroactive for all patents in force. So if you've got a crown jewel patent, you better be ready to bulletproof it. You better have affidavit testimony ready, and your affidavit testimony will be examined. There will be discovery so that they can take a video deposition perhaps of the affiant. And in addition to bulletproofing your own cases, you better figure who are your competitors, and you better have a proceeding ready to file against them. Why? Maybe you don't want to do it, but if they file against you, screw me, screw you, and you have basis to settle. So that's something you're going to have to worry about a lot, and that's something I've been talking about mainly, but it's not my topic today, so you can watch one of my other presentations on that. Substantive changes happen a little over 16 months from now. This is first to file, the big gorilla in the room. And be afraid, be very afraid if you're not used to first to file. Now, most of the world has done first to file. You're lucky I'm not in your area, because I come out of pharma, where first to file is a reality domestically. This can be done very simply, very easily by just changing a few procedures, and it's like getting a shot. Maybe you don't like to get a shot, but after a while you get used to it, and you've got time to get used to this new system, but it's coming on us very quickly, so don't put it off. Don't be afraid of it. It's going to work. So we talked about the IPR. All right, first to file. March 16th is the big kickoff date. Now, there is a seeming grace that you have priority to an earlier application. A priority application will be under the old law. So if the priority application is filed before this date, well, the old law will govern. But only if every claim is substantively entitled to priority. So what does that mean? You could have identical claims in a post-March 16, 2013 application to the earlier claims, but perhaps claim 1 is not really fully supported. It doesn't then meet the requirements for priority. Then you're toast. You're toast. You're under the new law, you're under first to file, and you're toast. What happens if you make a mistake and you have this one claim which is not entitled to priority and you cancel it? You're toast. Because if you've ever claimed something that's not entitled to priority, you're toast. So what if I file a continuation without this claim? You're toast, because you cannot go through a chain of priority through this poisoned application. So what's going to happen is you've got to file the actual filing date whenever possible, should be not later than March 15th of 2013. That's the last day of the old law. And like singing Old Lang Syne, toot toot, have a happy new year and all that. This is the end. This is the real end. So what is this going to mean for cases that are filed in the priority year? So from coming up in just a few months, from March of next year, we're going to start a priority year, which will then go beyond March 15th of 2013. You will have to try to have your actual filing date by March 15th. So that means if you filed 3 months before March 15th of 2013, you're going to want to file your convention application or your domestic regular application by March 15th. because otherwise you're taking a risk that your claims will not be entitled to priority, and then you're going to toast. And this can routinely happen. You may have an almost identical case that you're filing, or maybe even an identical case that you're filing after March 15th. And what happens? You have identical claims. Well, what do you do then if you have a species that is first disclosed in this later case? You haven't claimed it, but now you want to claim it. You can't add that species in that case, or you poison the entire case because it's not entitled to priority. Now, what you can do in that situation is you can file a further continuation off of this post-March 16th case, and that further continuation can be limited to that new species, and it won't have priority back before March 16th. It's a new species, but you can then prosecute that under the new first-to-file regime. So that's in a nutshell what we're going to have to do. Get ready for the 800-pound gorilla. Don't have time to go through my spiel about how you can simply file things under first to file. It's really not hard if you get the message. I've got a very short paper on that. I'm glad to send it to anyone who wants to see how this can operate, and it can work. Expanded prior art. This is an anti-patentee law. Now, aren't we in favor of the patent system? Well, if you look at the lobbying forces, patents have been a negative to many industries. Big surprise. So what's the best way to improve the patent system is to weaken it. And that's what's happened. And this is, if I have to make an overall evaluation, it's an anti-patentee law. It's not anti-patent, or it's to improve the patent system for those that that are hurt by patent rights. So that's what it is. Among the expanded prior art, under the current law, a foreign application, a foreign priority case does not have any effect in the United States as a patent defeating effect. This is the so-called Hilmer rule from 1966. So in other words, you could have, whereas a U.S. application is a patent defeating date based on a U.S. priority date, it hasn't had a patent defeating date as of the foreign priority date. That's changed under the new law. So under the new law, the patent defeating date will be the foreign priority date, and it'll be a patent defeating date for obviousness effect too. So one of the disparities between the U.S., it's not a harmonizing law in many respects. So under our U.S. law, we have a patent defeating date for obviousness as of the priority date. In the global regime, everywhere else outside the United States, a prior filed, later published application has a patent defeating date only for novelty as of the priority date. So this is one of the disparities in the law. Now, on sale and public use. Until now, this is a bar only based on domestic activities. Now it's global. So if you want to see a nightmare from hell scenario for finding evidence, consider the 1 million plus Chinese applications which are never filed in the United States. So these 1 million plus Chinese applications are prior art only as of their publication date, not their priority date 18 months earlier. So now, if you find a Chinese invention in one of these published applications, you cannot use their priority date because they haven't filed in the United States. What you need to do is to go to Beijing or Guangzhou or wherever their company is and find out if they had a public use or on sale situation, and then to prove that, because that is prior art. It's a foreign activity, but it's under the new law, all public use and on sale abroad is prior art. Now, one of the little fun things, ambiguities, Mr. Boundy was talking about ambiguities in the law. it's very unclear whether there is a grace period for a public use or on sale activity. Under the literal wording of the law, and this is what Justice Scalia would follow, only disclosures of the invention constitute grace period activity. But is, for example, a secret commercialization of the invention a disclosure of the invention? I don't think so. And even more fundamentally, is a secret commercialization by the inventor prior art or not? That's very unclear under the ambiguities in the law. Now, you could say, well, we want the patent office to tell us what they think. Well, I don't really care what the patent office thinks. It'd be very nice if they said this or that. But this is one of the quirks, one of the statutory ambiguities which will have to be straightened out ultimately by the Supreme Court of the Federal Circuit. Now, will this happen next year, next week? Well, let's take as an example the Section 103, the first time in our history, 1952, where we defined in the statute what is obviousness. So this is important, right? Let's decide this tomorrow. That was 1952. Graham v. John Deere, 383 U.S. 1, 1966, was the first time the Supreme Court dealt with a definitive interpretation of Section 103. That's, what, 14 years. So how will the Federal Circuit interpret this 5 or 6 years from now? I haven't got the foggiest idea. Why, am I stupid? Well, maybe that's true too, but the problem is we're going to have judges who are new. Outside of Judge Rader will be 65 in 4 years and can take retirement at that time. All of the current judges who've been on the court for more than a couple years, except for Judge Prost, who's going to last till about probably 2017, and Judge Moore, who's going to last forever, at least as far as my lifetime is concerned, they'll be on the court. The rest of it's going to be panel roulette among judges we don't even know who are on the court. So what's going to happen? I don't have the foggiest idea. Now, if the literal construction of Scalia becomes the dominant force on the Supreme Court, then probably secret commercialization is prior art. If legislative history is taken into account, probably not. Flip a coin. So avoiding first to file in 2012. We've gone over this, but I think it's important to reiterate. The year before, that should be March 16, 2012, the year before the new law takes effect, you're normally going to think of docketing your cases for 1 year later for foreign filing and for your regular application. You've got to docket them for March 15th of 2013, so you fall under the old law. You do not want to take a chance on having one claim found not entitled to priority under the old law, which will poison the entire case. So it's very imperative you file by March 15th, 2013, the actual filing date. Bubble filing date. Don't wait until the last week of this transition. There's going to be a huge number of applications unfiled, and every major patent firm is going to have overtime and all that to try to accommodate last-minute filings. But try to get your things in February if you can, because yeah. Yeah, it's not going to be as bad as the 1995 bubble, but it's going to be a bubble, and you want to have your cases very carefully prepared and prosecuted. So don't wait till the last minute on that.
One comment.
Yeah.
The servers could go down, so he's absolutely right.
Yeah, and
no more dump trucks.
Inventorship, I'm going to skip. Chico covered that pretty well. Now, here's the most... Chico, you want the microphone? Chico just always wants attention. He's had this, I don't know where he was raised. You grew up in New York, weren't you? No, Texas. Texas, excuse me. Here's the most important slide of all. Chico, you can say, trust Chico. No, don't trust Chico. I believe in Chico. Chico, you've got the best views on this. But in the end, the director is going to make decisions based upon input of the public. And here are the website. The Patent Office, this administration, unlike previous administrations, perhaps because of the availability of technology, perhaps because they understand the public should be served, this administration is doing its very best to get public input. It's your fault, it's my fault if we get bad rules. Now, I mentioned before the Patent Office is powerless to deal with the statutory ambiguities of what is prior art, but the Patent Office is empowered by Congress to create rulemaking. So for both post-grant review, which will be effective way in the future, and inter-parties review, the re-examination on steroids, there is a specific statutory provision for each of these laws that have about 10 or 11 points that says the director shall have regulations, implement regulations to deal with these various points. It's our fault if we get regulations we don't want. And so, well, how do you, does this mean you should just sua sponte go out and you should say, well, here's what I think? No, 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 no. Look at the bottom one, public testimony and implementation. Every comment, even when Dave Kapos' brother asked a little side question, that was published too. His brother's a patent attorney in California. But every comment is being put on the website. So what we need to do, if we're interested in one particular area, we're concerned about how the rules are going to be shaping up, read these comments that are on the website. And if you find a trend of comments going the wrong way, going south, it's your fault and my fault if we don't have our own comments. Because otherwise, we're going to get rules which are not what we want. And it's our own fault. Now, the most important person in the room, and one of the reasons I'm here to learn, is we have Ms. Gongola with us. She is the czar or czarina of rulemaking. She works directly under Commissioner Stoll, and it's her responsibility to put these rules together. So she'll get these things from Chico's buddies and see what they're doing and pass it around amongst the people upstairs, and they'll change it or play with it or agree with it. But whether they change it or agree with it in a large measure will depend on your own testimony. So read the Patent Office website. It's very user-friendly. I've been on programs with Commissioner Stoll, and I really believe him. He really wants to get input. And the person who's going to need a vacation for 10 years after this is over is going to be Ms. Gongola. And she's laughing now, but she's crying on the inside, I'm afraid. How did you get stuck with this monumental? It's an important task. Anyways, they're on the PowerPoint. These are people I've spoken with, and I acknowledge their great contributions. And my email address is on the bottom here. If you want any of the papers on how to do first to file, other things, or be on my list to get regular updates on this stuff, just send me an email. I have this very exclusive list. You have to ask to be put on it. And we have some people at all levels in the profession getting this. What my goal has always been is to disseminate information available to the public. On a quite serious note, when I was at the Max Planck Institute in Munich, the Max Planck Institute got all sorts of information that was publicly available, but these snotty boards of directors and all these groups would keep it secret. And so it's been my goal, if some information is available to the public, it goes out there. And so if I get information which I know is available to the public but is really not because people are trying to hide it, it goes out. And I try to share that information with the public. I think it's disgusting that these boards of these famous organizations try to restrict access to things. So I try to fight that any way I can. I've been doing that for many, many years. So we're running out of time, so I'll shut up and we'll get questions later. Thank you.